Hello, I'm Robert Bateman and this is the Privacy Corner where I talk you through my top 3 picks for privacy developments each week. And thank you, as always, to Privado AI for their support and for providing me with a new slide template for the week. See what you think of this one. So this week, the European Council adopted the AI Act, but we have covered that before. There have been lots of times that it's passed or it's been agreed to or some other significant milestone. So I'm looking to the Colorado AI Act, which also passed this week and is actually pretty significant, I think, and a bit like a shorter, simpler version of the EU's law. The UK's ICO has dropped a case against Snap, but it has said it might be speaking to Microsoft about its new recall feature, which you might have heard about. So we'll look at that feature, we'll look at what happened with Snap and what might happen with Microsoft. Now there's also a new version of the American Privacy Rights Act, the APRA, this new federal privacy bill that they're trying to get through, with some important changes and clarifications. So I'll talk you through those. So Colorado, the Colorado AI Act, I think this could be one of the most significant private sector AI laws to pass yet. It hasn't been signed, but I'm pretty confident it will be. Colorado's been quite bold in its privacy and sort of technology related lawmaking recently. It defines an artificial intelligence system quite differently from the OECD definition, still obviously derives from that, and it focuses, like in the EU, on high-risk AI systems that make consequential decisions. It applies both to deployers and developers of those systems. Now, consequential decision applies in a sort of limited range of sectors. So education, employment, finance, government services, healthcare, housing, insurance and legal services. And if your AI system substantially contributes to or makes a decision in those sort of realms, then it could be a high-risk AI system. And the bill is all about avoiding algorithmic discrimination. So that's treating people differently based on a set of protected characteristics, including limited proficiency in the English language, which I think might trip some people up. And so if an AI system causes algorithmic discrimination, then you could be violating this law. So it all starts with this rebuttable presumption, as they call it, and a duty to avoid or to take reasonable care to protect consumers from any known or reasonably foreseeable risks of algorithmic discrimination. So the rebuttable presumption, as it's known, is that if you comply with these rules, this law, then you are taken to have done that, to have taken reasonable care. That applies both to developers and deployers, but they have very different obligations. Developers are mostly required to provide technical documentation to deployers, so the users of their systems, and it's quite a detailed load of stuff. I've put some examples on the screen if you're watching, but this is a very small portion of the information that developers have to provide. It's stuff like a summary of the training data, testing, limits of the system, risks, benefits and intended uses, some disclaimer type things, you know, what you should and shouldn't do with it. There's also a notification obligation. So if the developer knows or that algorithmic discrimination has occurred or is likely to occur, they have to tell the Attorney General and also the deployer of the system. Now, deployers have the same rebuttable presumption and the same obligation to take reasonable care to protect consumers. And they also have to adopt a risk management policy. So this is an AI framework, essentially, AI governance or risk management framework. The law specifically name checks NIST, the AIRM framework, and ISO 42001, the ISO's AI risk management framework. Those aren't the only two, but they have to be equivalent to those. It also spells out some very specific examples of what you have to do as part of this framework, and you have to complete an impact assessment at least once per year for every high-risk AI system. There are notification requirements, very extensive to consumers, and it crosses over with the Colorado Privacy Act too, which has a right to opt out of certain types of profiling, which are relevant here. So next up, the ICO in the UK, the regulator for data protection here, where I am currently, has dropped a preliminary enforcement notice against Snap for an AI chatbot that Snap has integrated into its Snapchat app. So the problem apparently was last October when they issued this preliminary enforcement notice that Snap had not properly assessed the risks of generative AI in their app, particularly with children in mind. They have lots of child users. So this feature was called My AI, and it was essentially an OpenAI, GPT wrapper based on, well, I guess it would have been GPT-3 at that time, with additional safety enhancements and controls. The ICO never published their enforcement notice, preliminary enforcement notice, but we can assume that it had something to do with the DPIA. They said they hadn't sufficiently assessed the risks. But they dropped it because Snap apparently made changes to their processes and mitigated some of the risks. So then yesterday we had this news about Recall, Microsoft's new feature that takes a screenshot of your PC screen every few seconds. This is only on certain PCs, Copilot Plus PCs they're being called. They're not just Microsoft machines, they're being provided by Samsung and so on. They have a particularly powerful processor that works well for AI stuff. So Recall encrypts a saved copy of screenshot, will amount to thousands and thousands of screenshots of your usage history, and you can scroll back through and ask questions and so on. And obviously people have rightly pointed out there are lots of privacy risks here. It's all on device, so Microsoft's not doing this stuff in the cloud, but nonetheless this is pretty risky stuff, I think. So following the ICO's enforcement notice against Snap being dropped, it then said that it would be speaking to Microsoft about this new feature. And they said on X, formerly Twitter, I'm still going to keep up with the formerly Twitter stuff for another few months, I think, that they would be speaking to Microsoft to understand the safeguards in place, and that their investigation into Snap's My AI should be a warning shot for industry to consider data protection risks before launching new products. It's rather bold, I think, of the ICO to suggest that dropping a preliminary enforcement notice is a warning shot for industry. I mean, as far as I know, there was no actual warning against Snap or any reprimand or fine even, and they kept offering this product throughout the investigation. I guess they've made some changes internally, we don't know yet, but it's an interesting spin on the development, I think, in that case. So finally, the American Privacy Rights Act has had a markup at a House committee. This is all US legal speak. Essentially, there's a new draft, and they've made lots and lots of changes, some small, some big. The devil's in the detail. So I picked out a few. There are lots. One important one is to do with the data minimization requirement. So as you might know if you followed my previous posts on the APRA, the law would basically prohibit all processing of personal information unless an exception applies. And there are two main exceptions. The first being you can process personal data to provide a specific product or service requested by the individual. And you can also process personal data to provide a communication to the individual if the individual reasonably anticipates it. Now, one change in this new version of the bill is that it clarifies that that communication can't be an ad. So even if you say the individual reasonably anticipates an advert, that's not a communication as far as the data minimization rule is concerned. Next up, the sensitive covered data stuff was a little bit confusing. It suggested that you could process sensitive covered data with consent. You could kind of transfer it, as they put it in the bill, for any reason as long as you had consent. the new version clarifies that that's not correct. You still need to have one of the law's permitted purposes, and you also need consent on top if you're transferring sensitive covered data. Next up, the privacy by design. There's a whole new section called privacy by design. I think this was in the previous attempt at a federal privacy bill, the ADDPA, and it basically requires covered entities to implement a privacy by design sort of program, take systemic approach to mitigating privacy risks. It's quite a long section, very interesting actually, that if this gets through. And the data brokers have got a new obligation. The original version had a kind of right to tell data brokers not to collect personal information. The California regulator pointed out that in California they have something stronger than this, that this law would preempt. They can tell data brokers to delete personal data they already have. So the new version of the bill includes a similar sort of provision. Individuals will be able to tell data brokers to delete all the data they've collected on them and also not to collect any more. So whether that was put in with the Privacy Protection Agency in California in mind, I don't know, but it's a quite significant addition. Where the bill sort of will struggle is on preemption. I've already mentioned California's issue with it, and this is what will kill the bill ultimately if it doesn't pass. There haven't been many changes there. There is a slight broadening of preemption in some very specific areas, but nothing too substantial. So it could face the same problems as the last one. So that's all from me this week. Thank you so much to Bravado. I just hosted a couple of round tables for them in Amsterdam and Berlin. There's another one in London on June the 5th. If you're interested in coming along, then do send me a message and I'll connect you with the Bravado team, and I'll see you next week.